Hello everyone, welcome to Legaldarshana. In today's video, we are going to talk about the Mediation Bill 2021. Okay, so Mediation Bill 2021, Rajya Sabha ने December 2021 में propose किया था, and this year in monsoon session on 1st August, Rajya Sabha passed this bill. Okay, so this bill has been passed by Rajya Sabha. So before wondering to what this bill, when this bill will be implemented, when we will have the advantage of this bill, let's look at some key features related to Mediation Bill 2021. So here on the screen are some key features. Number first is pre-litigation mediation. So first thing we are aiming to do from this mediation bill is that both the parties must attempt to resolve their disputes among themselves. Okay, so basically what happens is जो mediation है, arbitration है, all of these are our ADR principles. Okay, alternate dispute resolution mechanisms, and the principles by which we resolve them. So it consists of arbitration, it consists of conciliation, it consists of mediation, and also a judicial settlement plus lok adalat. All these are the extrajudicial remedies, the remedies which are available outside the court, which the court can also grant. हमारे पास Arbitration and Conciliation Act of 1996 है, we have the act. But what about mediation? हम mediation अभी तक जो हमारा mediation govern हो रहा था, it was being governed by Order 23 Rule 3 of CPC. Okay, and when we read it with Section 89, जो section हमारा 89 है CPC का, वो कहता है कि कोर्ट को अगर लगता है the trial court or the adjudicating court, if the court finds it fit that a matter can be referred to alternative dispute resolution mechanism, then the court may refer the matter to arbitration, to conciliation, or mediation, lok adalat, or anything of that sort. Okay, but what is the condition is that when we talk about arbitration and conciliation, the consent of both the parties is required. Whereas when we come to mediation, even if one party is not consenting to mediation, the court can refer for even in mediation, even in judicial settlement, and even in lok adalat. Only for arbitration and conciliation, for these two, we need to require mandatory consent of both the parties. So till date, Section 89 से govern करके जो courts थे, they refer to mediation, and जो भी mediation settlement होता था, वो Order 23 Rule 3 के under enforceable था. So till date, we were using CPC primarily for deciding the fate of mediation. But since हमारे पास arbitration और conciliation का act है, then why not mediation? That is why mediation bill has been drafted. So अब जो mediation bill है, बहुत हद तक it will demarcate the line between mediation and conciliation, because it is one of the most occurring confusion between mediation and conciliation. What happens is mediation में क्या होता है? There is a third party mediator, there is a party A, there is a party B. Okay, and this third party mediator does not resolve the issue. वो अपना जो decision है, जो resolution है, जो suggestion है, वो enforce नहीं कर सकता. Mediator only facilitate the communication. Okay, he only says कि A ने ये कहा है, B ने ये कहा है. Whatever is your confusion, whatever is your dispute, you should try to resolve it by your own self. When we come to conciliation, what conciliator does is conciliator can enforce its suggestion. Conciliator को अगर लग रहा है कि दोनों parties mutually settle नहीं हो पा रही हैं, then in that case conciliator can enforce his suggestion that you should do this. Both in mediation and conciliation, there is no decision like किसी पार्टी के फेवर में डिसीजन नहीं होता है. So both in mediation and conciliation, a settlement has been to it is desired to reach out on a settlement. Okay, but conciliator can force that settlement, whereas mediator cannot force the settlement. Mediator just clarifies the communication. If both the parties are so resistant that they're not ready to agree on any terms, then in that case, the mediation fails. So this is a background of how mediation was working till date in our country. Now we are going to look at that what are the features that this Mediation Bill 2021 has proposed, which has been passed by Rajya Sabha in the recent monsoon session. Okay. Yes. So the Mediation Bill of 2021 has its key features as we are seeing on the screen. I am using this PRS India authentic website, which has all the legislative history. If you wish, you can also visit this website for more information. Now, pre-litigation mediation, this is one of the key features. So mediation एक्ट अब मैंडेटरी करता है कि कोई भी सिविल या कमर्शियल डिस्प्यूट है, सिविल डिस्प्यूट जैसे पर्सन A ने पर्सन Y को कार सेल की and they have a dispute related to the consideration amount, so they do not need to reach the court directly या सीधा आप consumer tribunal में चले गए या आप court चले गए. The Mediation Act makes it mandatory that you should resolve your dispute by mediation, out of the court mediation. Okay, आपने एक थर्ड पार्टी सी को mediator appoint किया and you try to resolve the dispute. But even if the dispute is not being resolved, then you can go to court, and the court can also allow mediation at a later stage if the parties request for it. Now, Mediation Act provides the list of the cases which is not fit for mediation. For example, there is a criminal case of murder. Do you think it can be resolved by mediation? No. Then there is a list that what kind of cases cannot be resolved by mediation, which includes the claim against minor or people of unsound mind, people in criminal prosecution and affecting the rights of third party. However, if there is a case of check bounce, this is an additional point. If there is a case of section 138 NI, can mediation be referred? The answer is yes, because the offences under Negotiable Instruments Act pertaining to check bounce, they are quasi-criminal in nature. Like these are the cases which are having the civil flavor. So yes, check bounce cases which are on the face criminal, they can be referred to mediation. But some list of cases which is like the claims related to minor and people of unsound mind, criminal prosecution, right of third parties, and also the this applicability. So the bill will be applicable only to domestic parties, and if there is a commercial dispute, agar commercial dispute hai, तब foreign party पे it will apply. Otherwise, it will predominantly apply to domestic parties only. Now, next is mediation process. This is one of the most important point which this act makes. Apart from what we have discussed, 180 days may plus 180 days. Okay, so the mediation bill suggests that the proceeding shall be completed within 180 days. और अगर 180 days में नहीं हो रहा है, तो on request of both the parties 180 days से वो extension मिल सकता है, but maximum 360 days, यानी कि within 1 year mediation has to be completed successfully, and a party can withdraw from mediation after 2 sessions. अगर party को लग रहा है that I am not comfortable with this mediation, the party may withdraw from it, but after 2 sessions. Okay. Now the next point is that mediators can be appointed by appointment of mediators. क्या है? Mediation Bill of 2021 बोलता है 2 modes. या तो आप by yourself parties आपस में decide कर लो कि this person X is going to be the mediator. और अगर आप नहीं कर पा रहे हो, then you come to Mediation Council of India. Okay, अभी तक हमारे पास Mediation Council of India नहीं था. हमारे पास Arbitration Council of India है, but with this act we want to constitute Mediation Council of India so that people who do not settle on the name of mediator within themselves, the Mediation Council of India may appoint a mediator for him or for them. Okay, so this is our Next point, that mediators may be appointed by the parties to the agreement or a mediation service provider. They must disclose any conflict of interest and they can choose to replace the mediator as well. So what we talked about right now is Mediation Council of India, which appears to be the next key feature. So central government will establish Mediation Council of India. Council will have a chairperson, two full-time members who are expert in mediation or ADR, three ex officio members, which is the law secretary, the expenditure secretary, and a part-time member from an industry body. And this function of council will include registration of mediators, recognizing mediation service providers and mediation institutes. Okay, so what this council is going to primarily do is register the mediators. So it will lay down the criteria that who can be a mediator, who cannot be a mediator, and then they can recognize mediation service providers, some institutes, and mediations and institutes which train the mediators, ताकि there can be a certification that this person is a qualified mediator and is competent enough to be registered with the Mediation Council of India. Then the next is mediated settlement agreement. So this is the most important feature, that agreements resulting from mediation. अब mediation दो तरह की होती है, इसके लिए we have to understand two things. One is court annexed mediation, जो कोर्ट रेफर करता है, जो अभी तक हमारा सेक्शन 89 ऑर्डर 23 रूल 3 ऑफ सीपीसी से गवर्न हो रहा था. बट सेकंड इज आउट ऑफ द कोर्ट मीडिएशन. ओके, आउट ऑफ कोर्ट, जिसमें कोर्ट इन्वॉल्व नहीं है, पार्टीज देमसेल्व्स रिजॉर्ट टू मीडिएशन. तो वो कैसे बाउंड हो रहा था? अभी तक व्हाट हैपेंड वाज वी यूज्ड टू रिकॉर्ड इट इन फॉर्म ऑफ द अग्रीमेंट. So that became enforceable as an agreement under Arbitration and Conciliation Act. Okay, but what happens now is that agreement which results from mediation will be final, binding, and enforceable just as the court judgments. Okay, but they can be challenged on the ground of fraud, corruption, impersonation, and relating to disputes which are not fit for mediation. अभी तक ये है that पहले दो तरह से मीडिएशंस होती थी, अलग अलग तरह से एनफोर्सिएबिलिटी होती थी. बट नाउ whatever mediation is being settled by the mediator under the ambit of this mediation bill, then that will be same way binding as that of a court judgment. But it can be challenged on the ground of fraud, corruption, impersonation, and relating to disputes not fit for mediation, which implied in an implied manner means relating to jurisdiction. This is jurisdiction, subject matter jurisdiction. Then it also provides a feature for community mediation. Suppose there is a district, there is an area named X, and people of this area are constantly fighting. So mediation bill also provides for community mediations. ओके, कम्युनिटी मीडिएशन से क्या होगा? 3 मीडिएटर्स का पैनल होगा एंड ऑल्सो वो लोग जो हैं दे विल ट्राई टू ब्रिंग द हार्मोनियस सेटलमेंट फॉर द whole of community or whole of the society. Now these are some key features which relates to mediation, but there is a lacuna. Whenever there is an act, whenever there is a provision, there is always a gray area. So what we have studied is we have So what we have studied is that pre-mediation is important. Pre-litigation mediation is important, right? That before reaching the doors of the court, you should try to mediate. But अब इसमें first advantage we have lesser burden on judiciary. कि आप बहुत सारे डिस्प्यूट्स ऐसे होते हैं जो मीडिएशन से सेटल हो जाते हैं. ये तो एडवांटेज हो गया, बट वी हैव अ रेड फ्लैग हियर. व्हाट इज इट? दैट एडीआर का मतलब है ऑल्टरनेट. ओके, जो स्पिरिट है मीडिएशन की स्पिरिट है वो इस तरह की है कि अगर पार्टीज चाहे तो, इफ दे डोंट वांट, नोबडी कैन रेफर देम. ओके, सो अगर आप प्री लिटिगेशन मीडिएशन को मैंडेटरी बना रहे हो, तो इट इज वायलेटिंग द स्पिरिट ऑफ इट्स ओन एग्जिस्टेंस, बिकॉज mediation is a kind of ADR, alternate dispute resolution mechanism. So if somebody wants to go to court directly and does not want to go for mediation, then this provision is breaching it, that the person has to undergo a mediation compulsorily. Okay, so for some reasons there is a lacuna. Next lacuna here is that this act says that the Mediation Council of India, when they make rules, they have to take approval of central government. Okay, which in itself is very a disputable fact, right? Why? Because there can be a government of India, Union of India, or states, the party to the ongoing issue. So when you take the approval of central government, it might create a problem. It might create a bias. Okay, so this is the problem, that there is a hidden lacuna which will come on surface later when the act will be passed. But from reading the draft mediation bill, this could be said. Okay. Then next is this mediation bill. It does not provide much for a lot of international perspectives. Okay, only in the commercial area, it allows mediation to be governed by Mediation Council of India Act, Mediation Council of India, right? Then the establishment of mediation council is also a concept of analysis. Okay, so we need practically we need to think practically, and to have practice mediators with adequate experience. Then the bill, yes, the bill applies to only international mediations when they are conducted in India. अगर इंडिया के टेरिटोरियल जुरिस्डिक्शन में mediation हो रहा है, then only the bill will apply, and only for the commercial matters of which one party is a foreigner party, right? So this is an overview of the mediation bill that has to be enacted if it gets approved and it gets presidential assent. But as of now, the bill that has been passed is based on these key features. I hope this video is useful to you. Please like and subscribe Legal Darshan and stay tuned for more such content. Thank you.